So in connection with the other videos, I just want to point out and explain something that we really need to contemplate and reflect on in its surrounding context, particularly going back and stripping it down and looking around when it was created, why it was created, following what events, for what reasons, what were the objectives in creating it. Look at material from around the time, what people were saying about it, and how they were talking about it to help clarify that, particularly like in the Karen Bowie paper, Professor Karen Bowie's paper. So then when we come to dealing with it now, we can find out and establish where it's been either misconstrued, wrongly interpreted, or the interpretation has been skewed or deviated from, and where we need to bring that understanding back on course. So I want to draw your attention firstly to the elections. Okay, so we've got, first of all, freedom of election. Now, the freedom of election is actually under the subject's rights here. The right to petition. Now, all these are in the same act, and I've done a separate video on this act, looking at it as an entire document, looking at its layout, its title, its opening part, the entire document as one piece, as one certification, so to say. What is this for? Who is it meant to be for? And what is its purposes? Covered that in the other video. Its opening piece starts on about evil judges, magistrates, and councillors, those who serve us, those who make judgments against us, and those we elect to represent us either in the council or in Parliament. And its main purpose is stated at the start of it, which is in relation to for subversions of the liberties. There were subversions of the liberties of the realm, therefore this bill is required to protect against them and protect against those people who might subvert them. So there are only key figures who have the power to subvert these freedoms and liberties, other than the king, the judges, the ministers, our representatives and councillors, because they are the ones who can make the decisions or do things that will have a legal effect on us. You can only have freedoms and liberties that are undermined if there is a person there who would undermine them. And it ain't going to be your next door neighbour usually. It's specifically setting out it uses the word evil, but I'll substitute it for naughty, for it's a more friendly term to use. It's about wrongdoing of councillors, judges, and ministers in relationship to the liberties of the realm. Right? So if these liberties of the realm have been subverted and undermined, then it clearly is indicating and setting out that, they're the subversions of what these people are doing. So these are to ensure that they don't do it. So if they do subvert them and undermine these liberties, then they are evil according to this act, which is, naughty, possibly even criminal. So, and that's what it's about. And this is why we've created these. And if you read the Professor Karen Bowie paper of Glasgow University, it tells you all the kinds of things that we were doing and what acts are covered and what type of things that people were doing when they were petitioning that would need to be protected and so forth, right? Particularly here also, it regards, bearing arms and putting together armies. So clearly those things are off the menu, using weapons and arming yourself and having, putting an army together, because then you would, it would be, if you don't draw arms on anyone, particularly, it's illegal to draw arms on the king, then you're not attacking anyone or putting them at immediate harm if you're not attacking them. And also, if you're not pulling an army together, then you're not going to take over the realm or the kingdom. So you can say we're more or less safe. Now, the main, we have to do this act because the American, all of the American Constitution and the First Amendment law, it hasn't come from nowhere. It has been copied over, even if it's been reworded. It meant something, and it had a purpose and meaning, and it bore relation to certain things in the context of those things, and that's the point in it, right? So in order for the period, for the era, for the time, for the era that it was written, we need to look at the contemporary languages. Now, in this act about subverting liberties, all these are not completely and totally unrelated. They actually they're all connected into similar activities and so forth. Like for elections, elections ought to be free, and bail. If people do get prosecuted, if it's lawful for them to be prosecuted, juries who are there are, not allowed to have groups of people that would be an army or threat, or, bearing arms for attacking people, and the petition. So the freedom of speech is really the starting point for the whole thing, particularly with the First Amendment, freedom of speech, the press, and petition, right to petition. Now, in this 1688 bill, it isn't just freedom of speech for anything. The freedom of speech is written out here in relationship to political matters, speaking about pursuing political matters, whether in private, in your own house, or in Parliament, or in order to bring proceedings to the Parliament, lay petition, gather petition, discuss it, get support, and then obviously hand it in and have it debated. The whole process from start to finish. People were getting prosecuted for speaking freely in their own homes, and that's in private, let alone in public. So, and this is the whole process of petition. Petition to the king is the proceeding of proceedings. It is an official proceeding, a legal proceeding to the Parliament. And therefore, because it is a legal proceeding, when you're engaged in it, it is to be regarded as legal proceedings to a jurisdiction, right? So, and if you've got a grievance of something, or you want something changed or adjusted, or if you want an inquiry, anything you want that the government can do, it's a legal case to the highest jurisdiction. So if it happens to be, for example, you can have a petition for appeal or for a pardon, but that would be about it's a grievance about an existing legal case that went through the other courts, whether civil or criminal, right? It can be an appeal to something, or it can be a brand new case. It can be fresh. But if you are bringing a case, then that is the case. People are talking about injunctions or other legal proceedings, but this is a legal proceeding, and it is meant to be straight directly to a higher jurisdiction. So you can't injunction it with lower proceedings, and you shouldn't engage. You don't need to You don't need any other court cases, and we don't even need to go into the ins and outs of the law. You don't have other court cases when you've already got one, because that's what it is. It's a court case pursuing something to the Palace of Westminster. So it's and if it is over a decision that was already made, then you are trying to get it overturned or changed. So you are appealing it. If you've got a grievance with something the government did and you want them to change it, and you're doing it by petition to the government, you are appealing it. That's what you're doing. So, how you, all these, like in Atlanta at the moment, they're doing a petition, and the local Atlanta cities wanting to have injunctions or appeal and so all these matters, but it's the council are not they aren't a party in a position to bring any proceedings against it unless they're challenging the legitimacy of it once it's finished, that it wasn't legitimately run. There is a special legal proceeding after it's completed where you can challenge the legitimacy of it. But as for like the Atlanta officials, they are fulfilling a intermediary role. They're facilitators. They're facilitating. And the thing with this type of case is that everyone has a say in it. So even everyone who works for the Atlanta City Council has a say in it, as well as the citizens. Therefore, they are already engaged in the case. And they get to choose a side. They're not another entity as the council in it. They are facilitator. Facilitator can challenge the legitimacy of it, or any person can challenge the legitimacy of it. But as for the outcome of it, or taking a side in it, they've already got a chance to take a side in it. And then, because they are already a party that participated in the decision, because the decision's down to the voters, they as a facilitator, they're not in a position to challenge the outcome only if it was run legitimately or not. I think that you can take it to a higher level and take it to federal government. But it's the role, they're just misconstruing the whole roles of the people in this. Now, with when we get into these processes, because it's proceedings and because you've got rights, they were trying to stop people from even, engaging in these proceedings at all whatsoever. And that's when the liberties of the realm were being subverted. Now, the freedom of speech here, it's actually in relation to the matters that are going to be brought to Parliament, or when they are being debated in Parliament or actioned. But obviously we have a role in that because it's our case. If someone punishes you, you're the victim, and then you get interviewed and questioned, and there's an investigation. All that is part of the case. Whether it takes part outside of the court as well as inside of the court. This is the thing. This free speech is in private, and when people are going around gathering information and talking about it, free speech, and then when they hand the case work to their elected representatives, and then inside Parliament as well. But it's definitely free speech. When we've got free speech here, it is actually in relation to the political process, actually, not just, going to the shop to buy some sausages or whatever. It is actually, I thought it was, when you read the American one, it just says the right of free speech, petition and freedom of press. They all seem completely separate and related things. In here, right, many of these things are related together, particularly politically or in the justice system and so forth. Now, the thing is, with the right to... What was happening in this Professor Karen Bower paper, she said that they were charging people for submitting petitions, charging a fee, trying to charge them money for submitting petitions. you have to pay money, you know, like for civil court cases, or, you know, you don't pay for the criminal unless you get convicted. If you get convicted, then you pay, but, you know, if it's paid for by the taxpayer, the process is there. It's a miracle, actually, in America with, you know, the health service, when you've got to pay for healthcare. It's a miracle that they don't make them pay for the police, you know, beforehand. You know, well, they do pay for it through taxes, but it's amazing that they haven't got private police, and that they force people to have to, you know, if you want the police to go investigate someone, they make you pay money. I'm quite surprised they don't even do that in America, the way they're going with the healthcare. So, freedom of speech in this bill, which is meant to be the one that the American one's based on and around, and contemporary to it, this is in the petition is in the Karen Bowie paper. It's a legal process that actually had Lord of Articles, or in the Tumultuous Petitioning Act, 3 justices or a grand jury, or the London magistrates, which clearly is signifying that it's to do with London, not local courts around the country or local circuits around the country in minor courts. It's definitely a matter for, it's the magistrates of London. The King, Parliament, and then we've got this Lord of the Articles. These are all at different periods. But they were trying to charge people for the petition. Now, in this act here, in the right to petition, it clearly states that it's the right of the subjects to petition the King, and all prosecutions and commitments for doing so are illegal. So if you can't be held to any commitment, then they can't make you do something. A commitment is we're going to make you do something, hold you to something, right? So they can't charge them. They were charging them, and they put a stop to it through this, right? Why doesn't it say? Why doesn't it say that, you know, petitions shall not be charged, they ought to be free? Well, it doesn't need to, because they've gone further than just saying that. They could have just said, you know, all petitions ought to be free. But if you're going to go further than that, we'll just make them free. We'll make all the prosecutions against them are illegal, and all commitments. You know, that's not just free, that is the free and more and extra additional things, right? That's the point. Now, when we go down here to the elections, freedom of election. Now, it doesn't actually say it's the right of the subjects to run for election, and all prosecutions and commitments for elections are illegal, does it? It says elections ought to be free. So they're saying that, well, you know, we're not going to charge people for elections, right? Now, the thing is, when you are running an election, really, you are the people are petitioning for someone to represent them to the government. We want to be represented, you know, and we're going to vote for who we represent. It is a petition. So this is how they're all, they all work together and complement each other through logic. Why? Because they are all proceedings, and they're all petitions. And the freedom of speech is for political matters in cases being brought, which is by petition to the government. So the freedom of speech from us to the government applies to the right to petition. But the thing is, with the petition, you know, you need to speak. You actually need to talk about it. You know, you have to go write it down on paper. All prosecution, it says all prosecutions, that's legal cases against you, and commitments to be held by. They might try and stop you from speaking. They've got free speech down here, and it's clearly, it is in and out of Parliament, but for that process. Now, going over to the American First Amendment, it says a redress of grievances to the government and the freedom of the press and speech. That's in the same amendment, in the same bill. So it isn't actually a major fundamental law of America, the Constitution, for, just going out and buying a sandwich, is it? It's about things that are required, necessary and protected when you are engaged in those things. Now, why is it got, in addition to just the right to petition, it's got elections and free speech, just so it makes sure that you know that these things are also covered. But we know, we have to already know that an election, you're petitioning for Parliament for someone to represent you. You're petitioning the Parliament for a minister to represent you, right? That's what you're doing. But you have to know that. If you know that, then you know that. So then you know that the right to petition applies to elections as well. Because also does free speech. Because you use free speech when you are petitioning the government. Or else you can't talk to anybody about it freely. So these are combined and used together as well. If you can't do these things, it is regarded as subverting the liberties and freedoms of the realm. And the people who could put a stop to that, I mean, your neighbour could try and stop you, but, your neighbour could try and put their hand over your mouth or whatever, but ultimately, they don't have any legal power to stop you. They don't have any legal power to stop you until, Facebook and YouTube give them loads of little happy-go-lucky buttons they can just press willy-nilly and do what they want to you, and then you're physically stopped. Although I suppose someone could grab you, but then you can, fight back, and then it comes down to who says what. Now, if at any point you need to exercise these rights, if you were having a meeting and someone, did try and stop you speaking, then you would need to be able to speak and say, excuse me, this is, a political, we're doing something for, petitioning. Do you mind? We've got rights. If you can't say that, you can't tell them. Or else you have the right to remain silent. You can choose not to speak, but you have the right to speak and inform them. Or else, you got the right to speak, particularly in matters to proceedings, because really that's when you want to speak. If someone's going to arrest you or take legal charges or have a case against you, you need to speak and tell them what's what and what the truth is, particularly when you've got rights, or else you don't even have the right to give evidence. You can't even give evidence, although they compel you in a court, when you're under oath. But this is the thing. It's more than under. The thing is, in court, when you're under oath to tell the truth, you've still got free speech. Now, that's in a criminal or civil case. The thing is, when you're doing a right to petition, it is a proceeding to the Palace of Westminster. It is legal proceedings. Now, if you don't have someone there saying, you're under oath, but like in a court, when you're speaking, you need to have the freedom to speak. You really want to compel yourself. In fact, if you've got a grievance and if you've got a case that needs to be brought and it's really a grievance, then the grievance will compel you to speak and seek out other people and tell them about this issue or matter. You are compelled by your own will. That's why you're doing the petition. It compels you to speak about the issue. You don't need the court to compel you to speak on oath. And if you don't, if the matter is not valid, then why would anyone support you? And at the end of the day, you are trying to convince people of a certain matter or lay evidence. Now, this is the whole thing when it comes to what's true or not true. No one knows what's true. At the end of the day, unless you go to a court, you can challenge anything. Apparently, they are challenging anything in America now. They're trying to, you could go into you could go into the courts in America with a dictionary and challenge it, right? If you wanted to. But if you don't challenge them on it, no person has a authority or power to make an order on it. That's the thing, unless they're a judge. You can even get the dictionary abolished if you want. You could go to Parliament and make dictionaries illegal if you wanted to scrap the whole thing. This is the point. You've got to be able to speak, and the thing that everybody's missing in this whole thing is that the petition is a reverse format of proceedings to a court. Instead of having a jury next to the judge in the court towards the end of the whole affair, it is ordered differently. You go to the public first and get as many of them as you can to take a side. And then the case is taken to the Parliament. And then you've got your advocates who are meant to debate it. And then, decisions get made. It's a different format of order, but nonetheless, it is as legitimate and predates even Parliament being elected and called forward. I don't know whether it predates actual, criminal proceedings or civil proceedings, but one thing is for sure, apparently it goes back a very, very long time. And, then you're arguing which criminal proceedings, because there were the Danish criminal proceedings, there were the Irish criminal proceedings, there are, the Normans criminal proceedings, there are Anglo-Saxons criminal proceedings. So you're going, all of them had them. So it's, and in the Professor Karen Barry paper, they're going on about this right to settle grievances going very far back. So it is to do with it is to do with actually electing. It's to do with electing people who are going to be in charge, and even who the juries were meant to come around and do judging privately. That's the thing. So I think it rests with the whole power of the village to elect and choose who's going to be in charge and make up the laws. And if you don't elect someone in the old Irish legal system, of which surely the clans, the organisation of the clans must be connected to and built from, because that's all that's left of them. So that's all that we have. That's the only knowledge that we have, and it fits. If the people of the clans were electing someone to be in charge, a council or committee or kings, and then the people they elected, they made the laws up, and then when the Druids came around, the Druids were independent, but they, had people, they got the independent Druids to judge the matters, and they were truly independent, because then they weren't too familiar or didn't know people too well, so it would be very, very impartial. So this citizens' right to actually, if you can elect a council to be in charge and then they get to choose what the laws are, how can you enforce the laws and then arrest people or bring civil or criminal cases against them? Because you don't have any laws if you haven't made any. If they haven't elected who's in charge, they elect who makes up the laws, and then you go enforce them. So the election and petition, maybe even the people, as well as electing them, they could actually put suggestions forward for what the law should be as well. That would completely make sense. So you don't actually have any laws, and you can't prosecute anyone or have a civil case if there aren't any. And if you're electing people who are going to make those laws up and deciding what they're going to be, then surely it is before all criminal, before the concept of civil and criminal, because you ain't got any laws to start with if we don't elect someone to have them or decide what they are amongst ourselves. So there ain't even any criminal or civil cases unless you've just got, some authority going round who takes over the place and then puts their own, they put the laws down and they're not elected, which then you would say, just a minute, this is our country. Who do you think you are? We decide, we make decisions around here. Oh, no, you don't anymore because you've been conquered. Oh dear. Right, well, we're going to have to fight for these issues and laws then. And then there you go. Here it is, it's still here. And in fact, they're trying to, the king's conquered us, and now he's trying to subvert the laws and liberties of the realm, which were there before we were conquered. And if the Americans believe in the right of someone to come over and conquer someone, and then they make the laws up through the merit of superior military firepower, then you might as well scrap the whole thing. Because that is not what this is about at all. So going to the American version. So the American version is the right to petition for grievances, freedom of speech, and freedom of the press. Now, if it was based on this, which everyone says that it is, and if it has any relevance to it at all, which it does, and if it is meant to be an American version of it, which it is, then all those three things, the right of freedom of speech, to petition, and of the press, really, like in this one, must really mean in relation to those proceedings when it concerns matters of the country. Right? It has to, because in this one it does. The freedom of speech is in relation to matters of the country they were bringing. The right to petition not being regarded as a criminal or imprisoned, as it says in the Scottish version of this act, not being imprisoned or held to any commitments like being charged for petitioning, which we know they were doing according to Karen Bowie. This is exactly why it's got in here the freedom of election. Elections ought to be free. Well, they were charging for petitions. So, they weren't about to let them charge them for elections, right? So you can't charge them for petitions when it says all prosecutions, but also commitments are illegal, because that, what's the point in writing the same thing repeated? You won't write freedom of election ought to be free, right to petition ought to be free, levying of money ought to be free. You won't write the same line multiple times in the same thing, You have to be intelligent. You have to have initiative. Why? You have to question it. Why is freedom of election? Well, because they've already tried to pull that one on the petitions and tried to charge them for it. So now we're going to stop that. Well, we'll make all commitments illegal for petitioning. And just so you know, do you think that might mean charging for money? Well, actually, what if we'll try charging for elections instead then? Well, no, you can't charge them for elections either, it says. Well, charge them for petitions. No, all commitments. Well, just a minute, isn't an election a petition? Well, very clever. Why didn't it say right to petition and election? Well, it's freedom of election. Election of members of parliament ought to be free. So, because that's the election of members of parliament, and petitioning is us actually instructing and directing them through our petitions. That's it. Because it's two separate. It is another thing. Oh, and another thing. And another thing. Criminal proceedings. Oh, and another thing. Civil proceedings. Oh, and another thing. We'll get married. Oh, no, just a minute. If you've got a clause to do with marriage, if you had a clause in here that said was about civil cases, but then later down you had another clause that was about marriage, the thing is, the marriage clause It is a civil case. Because when you get divorced, it's a civil case. So if you had a clause in here that said, the right of petition or civil cases, then later down it says, in regards to marriages, well, when you get divorced, it is a civil case. Marriage and divorce. If it was a clause for marriage and divorce, that's the type of logic it is. And freedom of speech definitely is in regards to Parliament. So some of these are cumulative. Some of these apply together or separately, depending on what it is. Clearly, freedom of, and I think the freedom of election ought to be free, which it also suggests that not only free for money, but free, you can speak about it freely. Got free speech, because this free speech clearly applies to elections because it's regarding members of Parliament. And the freedom of speech is also concerning Parliament as well. So it's just, when you read the Karen Barry paper, it explains the whole context of what was happening and what sort of things people were doing. Rebellious behaviour in public, all these things. Why did they create this act and give immunity? Why would you give someone immunity? Well, the thing is, there are loads of immunities, like, people are knocking houses down when they don't have the legal authority or right to knock it down. They don't have permission from the government to knock it down, yet they're not criminalised, they are just fined, planning breaches. So there are loads of things that get demolished and destroyed and people aren't subject to being labelled a criminal. So with petitioning, they're just, they're not going to criminalise people. So the main point, and I really didn't want it to go on for this long, is this. In the American bill, it has to be that the freedom of the press, what is speaking, it is everyone politically talking. This is about speaking in Parliament, but also bringing matters to Parliament. And when you petition the public, you have to first take it to the public, whether that's in private or around public, to tell people about it. It's part of the functionality of it. It's serving a function, and we'll get onto that later when it says, publishing things. There's a requirement in law to publish as part of its function. Now, it's a requirement of function to speak about the petition, or when you're running for election ought to be free. Elections ought to be free. Free speech in elections, as well as not paying for them. Clearly, if you've got below it the freedom of speech, right? And if you can't be prosecuted, there's nothing that we can really do to stop you speaking freely, because the only thing they could do is, no one can stop you doing anything, really, in the first place. It's meant to be the law, the threat of the law, or the word of the law that compels you to not do it. But, you can, it's the consequences that get you. It's the consequences, the prosecutions, the convictions, the fines that get you afterwards. And that's meant to deter you from doing it. When you have freedoms and liberties, you don't want to be deterred from exercising those freedoms and liberties. Now, I think it's a no-brainer when you actually fully understand the whole document and its surrounding context and purpose. The freedom of the press must be and has to be, is grouped in the same sentence as freedom of speech and to petition, because you would use the press for doing it. You would. Particularly around America, federal law, because how are you going, if you're petitioning the federal government, you ain't going to walk around America, and your jaw's going to ache. I'll tell you that. It'll fall off. You ain't going to have no jaw left. If you can petition federal government from Kansas, you've got a long walk. If you need 100,000 signatures, you're only going to petition them from the people of Kansas. Federal law, apparently anyone can sign if you're petitioning the White House. So, explain to me this then, Neil Mohan, Chief Executive of YouTube, and Paul Groves. Riddle me this. How are you going to petition federal government in 1787 with 2 legs and 8 teeth missing? You ain't going to get diddly squat if you can't use the press. Nothing. So clearly, it is the freedom of the press for petitioning and the freedom of speech for it's meant to be the political matters, and it is meant to be in context of this one here in relation to political matters and proceedings. So it actually isn't really supposed to be just, anything. But the way they've done it does set a new precedence of, and a new standard of, freedom of speech for all, the freedom to speak freely in general. But it still is grouped together because it is also meant to be an expression of this here, this bill. So you would add in, the press was relatively, 15 and 1600s, the press is relatively newish invention, and as it grew, so here you've got your right to petition and freedom of speech, using it in these proceedings and elections, and then they introduce, in addition, the press. So it isn't actually just, anyone who owns a newspaper can do what they want, listening to people's phones, publish what they want, blah, 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 blah. It's not actually about the newspaper owner at all. It's about the press as a vehicle, the press as a medium, the press as a resource like free speech is and like writing is. Because the petition, you really would write it by hand. But obviously, if you've got the freedom of the press to use, you can do a lot more with it. So, petition, particularly in elections, or you have to write everything out. Like even election forms, freedom of the press for election forms and so forth. Now, this is when we get to the newspapers themselves. What evidence is there? Well, so the newspaper, right, we need to really, 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 really understand what the newspaper is without taking it for granted. Without just taking it for granted like this is Rupert Murdoch, this is someone's, what is the newspaper, right? And what is the process of its function? So let's start with a blank sheet of paper, right? Let's start with a complete and total blank sheet of paper, right, that's got nothing on it. And someone's got a machine that can, duplicate whatever you want. Now, the thing with the newspaper is that, now, books, like publishing books, if you want to publish a book, a publication, you go to a publisher, you publish a book. That is the press, but that's your book. But we're talking about the intent of the newspaper because it's different to a book. What is the newspaper? And if you want to start a newspaper company, right, what is it that you are providing? And what is the point in it? And what am I providing here? What we're doing? If you want to have we've got toilets in the public, we've got public toilets and you can go use it. You could have a private toilet if you wanted to own one and charge people for going in, or you could have it free. But why would you want to own a toilet block cubicle? I'm going to choose what business I want. I'll have a toilet cubicle because, I really like, what I'm interested in people going to the toilet and taking a pee. So that's what business I'm going to have. I'll charge them some money, right? If you don't like people taking a pee or going to the toilet, then it's not the business for you. If you want a private book publishing company where one person publishes their story according to the law, what's legally in the law, not policy, we're talking about what is possible or not possible legally, right? Then you should do that. But a newspaper, to choose to be a journalist, right? Now, if you've got a table with a blank newspaper on it, there's nothing there, right? How does anything appear in the newspaper or on it? Well, you've got stories, but they're not meant to, if everything is, true and honest, they aren't sat there writing novels. They aren't sat there making stories up, although some would, be dubiously, someone would question whether they're making them up now these days. That's the thing. Are they just sat there having a laugh and making these stories up? But it's not meant to be fiction writing. It's meant to be reports or stories. Now, we need to go back in time to, the 17, 18, 1900s. So, what is it? It's about hearsay. It's about what happened or what someone said or did right or did wrong. And the whole point in the newspaper is that actually people come to the newspaper with stories. People would write into them. In fact, the newspaper, it's like a supermarket. If no one brings you eggs in, you ain't got any. If no one brings you flour in or soup or anything, you haven't got anything to sell. So people come to the newspaper with stories. Oh, I've got a story. Now, the newspaper, some newspapers, they will print people's stories if they're interesting, or, if they're, they might have a slow week, you might not be busy. People go to the newspaper with a story, right? Because something happened. Now, you might actually get paid. They might pay you some money for it. But mainly, you don't necessarily get paid. You've provided them with a piece of information of something that happened, right? Now, there's many things in the newspaper that haven't been correct. I've checked a few stories and I chased up, the councils and versus the person who published the story, and it wasn't even the right facts. It was completely and totally, the information according to, the person on the council wasn't even what the newspaper reporter writ. So, that's a joke to start with. But it's meant to be. People actually come to the newspaper with stories, because they're telling them what's happening. And it's meant to be like, some newspapers are free because the adverts pay for it. Some people give the newspaper money in order to have their commercial business in there. And they let people know about their businesses, right? But also, there's these stories, what people come with, they don't pay for them. They might even get paid, but they don't pay to have their story in there. The newspaper provides a service for anyone's story, and no one even knows whether they're true or not, half those stories. But then, as well as stories and news of things that's happening, and as well as these commercial companies who are advertising in there, you've also got this public notices. Now, we don't really, in the 1980s or through the 1990s to early 2000s, they sneakily and slowly phased out these this public notices, and you didn't have to pay the newspaper for them. Why? Because when you go to a newspaper with an information, you're laying in information like a story, because that's what they do, publish stories. You don't pay the newspaper. They are wanting people to go with their stories, so they've got something to tell people. That's the point. Now, commercial businesses aren't telling a story. They want to sell products and make money. But that's convenient for the newspaper because it pays for all the printing and so forth, right? Now, public notices. There's always been public notice boards everywhere, all around in the villages. The council provide it for you through taxpayers' money. Why? Oh, it's printed because the freedom of the press to publish a notice in the local notice board by the council. But also, the newspapers provided a section for public notices that people were not making a financial profit out of. Likewise to the stories they came to the newspaper with that they were giving them for free, depending if the newspaper was interested in it or not. See, I am doing a petition and I want to inform the public of some information. Effectively, something's happening, it's a story, versus, oh, something happened. Something happened on the way to the forum. I'll tell the newspaper about it. There you go, there's a story. Brilliant, we'll publish it. We like this story, right? Oh, by the way, I lost my coat in on the train. Or, I lost a hip 20 piece on Barter Street. Has anyone seen it? Or, I've lost my daughter. Can anyone identify her? Can you give me a description of her, please? Yes, I lost my daughter. We can't find her. She's got this description. We'll put it in the newspaper. In fact, maybe the police would ring up and say, we've got a criminal case and we need witnesses to come forward. This is for proceedings. It's illegal. So I think that this freedom of the press, they knew about the freedom of speech and they knew about the freedom of, the petition. And then when you've got a newspaper, what is the newspaper going to publish? Stories that people come into it with, right? But then you've got this whole bias. Well, they were very clued in on bias. That's why they've got these liberties. If they fought for these liberties to be able to petition on whatever they want, right? And speak about it. They fought very hard for it. So it would have been natural to extend it also to regard anything that is written by hand under the same legal rights as anything that you would speak from your mouth. At least in relation to these political matters and so forth. Might not extend to everything and anything, but it definitely does in regards to political proceedings and for Parliament, because that's what the freedom of speech in the Bill of Rights is actually mainly concerned with. So I think, I am absolutely certain, and we need to do the research for this, I'm certain that when they invented the newspaper, they set aside this public notices section because we've got a freedom of speech. But that's kind of there in the stories, though. But then you might say, oh, well, the newspaper might pick and choose a story or refuse it. Well, if they refuse to run, a story or whatever, but a petition or an election is not like a story. It's something that actually is happening through a government process and procedure, right? Legal proceedings and law. And this is the thing. Legal requirements to publish. There are legal requirements to publish, and it states either by standing orders or by certain regulations or requirements. The petition, the government website says publish and share your petition on Facebook, YouTube and Twitter. Or not, well, it means Facebook, YouTube, Twitter, and actually email as well. you know. So it's actually telling you to publish on these platforms, which is a direction from Parliament. It actually is a direction. And the required function is to tell as many people about it as possible, because that is a function of a petition. In order for the petition to function and operate, you have to tell people about it, and that is speak. If you can't speak, you can't tell them. And, you know, in America, if you were petitioning the White House in 1700s, if you were petitioning the White House over federal law, how are you going to accomplish that? Just by talking? You aren't. Or just by walking Route 66, you aren't. It's only achievable through a newspaper. Therefore, if it's only achievable through a newspaper is critically important, or it's impossible to do it. Therefore, if it's critically important and impossible to do it without the newspaper, then you clearly would have the rights applied to the newspaper as well as your mouth in free speech. And that is why I believe they've always had this public notices part set aside to acknowledge that. And then they've got their own stories that people come to them with anyway. And then if it's anything commercial, profits to be made, then it's advertisements. So that's how they make their money from businesses. But the newspaper is a business. It's meant to be a community thing. That's why they give the news. They want to tell people what's happening. They really want to know. You know, Mrs. Bibblethwaite's petitioning for a new school. And then, you know, or someone lost their cat. Or, you know, whatever it is. Or, you know, someone lost their, threepenny bit or something in the pub down the seat and they can't get it out. You know, and the landlord, refused to lift the seats up to get it out, you know, and therefore they're, you know, well, whatever it is, you know, there's something. That freedom of speech and to petition and the press, they're all interlinked together. And I think it's the freedom of use of the press. Not just freedom of the person who owns it. The press is freely accessible, so to say. The freedom of accessibility. And I think the type of language they're using in this, it says, and straight away in the opening bit of it, you mean there's kind of like waking up and smelling the coffee, but then even when you woke up and smell the coffee, then there's like, you know, popping out of it again and waking up, and then there's even waking up from waking up, and then there's actually being awake, right? What is this? What are we actually looking at? This is the First Amendment to the United States Constitution. It's not state law. So it's not actually, you know, state laws for, you know, whether chips are illegal or not, or, you know, whether or not you can smoke in public. That's state law, right? This is the fundamental constitution of the whole of the country, right? And it says it prevents the government from making laws that regulate an establishment of religion or that prohibit the exercise of religion or abridge the freedom of speech, which is what YouTube are abridging the freedom of speech. They are doing. That's what they're doing. The freedom of the press, the freedom to assembly, and the right to petition the government for redress of grievances. Well, the petition you need to assemble. And in the Karen Bowie paper, they were assembling in public for petitions and speaking about them. And that is why they were trying to prosecute certain people, stop them doing it and so forth, and rebellious behaviour in public. And it's regarded as subverting the liberties of the realm. Now, here, it's got those things. Assembling together and petitioning and speaking freely, but also publishing it. This is not like, this is not Tom, Dick and Harry. It's not like, It's not like National Pontoons Holiday. Oh, look, there's Mr. Bigglesthwaite. He's fishing there. You've got freedom of speech there, Mr. Bigglesthwaite. Yes, and here is a group of children gathering together and assembling for a baseball game. And then we've got, and here round the corner is Mr. Shankensbury, who owns a newspaper. Oh, I've got freedom too. Oh, it's not just for you, just for you, just for you. It's not for who, just for you. No, it's not for you or not for two. It's for all of us. Yes, I can use my mouth. And we can gather together. And surprise, surprise, we can use the press. Because, here in 1784, it would be very difficult to petition the White House for redress of grievances without a newspaper. This is it. So it is publishing. Now, it's true there are private publishers who publish books, but the thing is, when you choose to have a newspaper, it is there, supposedly, you want to, what it is I want people to come with me with stories and tell me things. And this, I'm meant to be telling people what's going on. And I'm not going to charge them for it. And also, by the way, they've got certain rights as well, which I'm accounting for, particularly if it's anything to do with the government, the establishment. They'll be assembling outside and having grievances with me soon if I don't publish their petitions. We've got a right to. This is it. That's what it is. Now, companies aren't petitioning the government, although they've started lobbying now, but they're meant to be actually selling services and goods to the public. That's not seeking redress with the government. It's selling goods to the public for a profit. When you're petitioning the government of a redress of grievances or going for election to be in the government, you aren't selling widgets. You are merely, it's a function, and these are required. These actually required as part of its functionality. To function properly, you need to be able to publish it, and that's why you've got a right to do it. And if you want to own a newspaper that claims to be a newspaper, then you just chose the wrong business. Boy, I want to have a private newspaper. Well, newspapers aren't private. That's why it's called a newspaper, because nothing in there is private. It's other people's affairs and stories that were happening. A private newspaper. Just a minute. My own private newspaper in my own private house. I went to the sink. I turned the tap on. I made a cup of tea. And then I went into the living room and turned the telly on. Then I looked out of the window and see some seagulls flying over. And then I sat down. That's a private newspaper because it's your own private affairs. Oh, no, I want to tell people what's going on in public. Oh, do you really? That's interesting. There's a lot of things going on in public then, Well, there are certain laws, You can't slap them around the face at the till, like on Fawlty Towers, like Emmanuel, like pick him up and shake him around, or push them down the stairs like Laura Ashley, or whatever, there are laws. Well, you've got to have people can, express freely what they want. The worst thing is, well, not the worst, but they weren't charging people for public notices or taking sides. And these free public notices, some newspapers, I don't know how many left, like in Bristol or wherever, they've got you can put a free notice in there, but they quietly phased them out. I wouldn't be surprised when it was after 1986, Tumultuous Petitioning Act was, abolished or, taken apart. But I still think they were doing it in the early 90s, possibly. I seen some maybe about 10 years ago, actually, I've seen a few small newspapers still doing it. But that is the tradition. It's what it actually is. And it's actually these corporate entities that have slowly actually bought up these newspapers and taken over them. And then all that they it's been subverted and perverted into like, only graduations in university, celebrations, if someone's passed away and so forth. And it's very, very restrictive in what you can put. They actually built it into this very, very solid regime framework website where it was the same website for every newspaper. And there was no other reason to do that than they wanted to try and control people with it. And they still called it public notices, but they they forced the framework so the forms would only accept certain things. And they still called it public notices, but when you went through the options and the drop-down menu, there wasn't really anything for a petition or whatever, but that's where it's meant to go. So what actually happened on the websites for the newspapers, even though they were still stating the statement and so forth, you could have actually rung them up and submitted it, actually given the statement what to say, or a picture or whatever by phone. But by those forms, they really tried to stop people doing it, even though that is what it is meant to be. And YouTube really, I haven't had any problems with YouTube. I've had my account for 10 years and I've kind of put whatever I want, more or less. But until February, I never had my channel taken down. And it was only after all this whole issue with the whole lockdown and the whole pandemic thing. And I really... I didn't have a problem with it, really. There was copyright strike problems, and then that kind of got sorted out where they pretty much let you either at least, edit it or change it without getting a strike, or you usually get permission. So there was an entity behind it that wanted to change the whole system for all the newspapers to use a online drop-down menu that was shaped to only have options that they wanted you to have, because they didn't really want to give options, but those options existed in other newspapers, so we know what it is meant to be. And it is the same law. I put a petition in the London Evening Standard, and I've had no problems with them. And then I put one in more recently, and it was kind of not affiliated. It wasn't aligned with the newspaper's kind of like, slant political alignment. But I argued with 5013C, illegal campaign intervention and right to petition. And I said, you can't refuse. You don't have the right to refuse, because it's meant to be public notices, and these are legally required, actually. We don't have to, but it's almost like the right to remain silent. The right to, when you get arrested, it is a legal process. In fact, the citizens, there are a few different acts of law that have got arrest rights in. But when a police officer arrests you, then he's going to, question you, take you to the station and possibly charge you or whatever, right? That he's using the law. He's using law, right? The newspaper owner, if he gets arrested, doesn't say, unless he's got a lawyer there or tries to use some other legal excuse. If a policeman wants to arrest the newspaper owner, what's the newspaper going to do? Oh, I'm a private person, you can't arrest me. No, that's the law, So, he reads him his right. He reads the rights. Say that again. He just doesn't say his rights. He says, read him his rights. Read him his rights. Read him his rights. It doesn't say, tell him his rights. Tell him his rights. It says, read him his rights. You have a right, actually, to remain silent. But if you do so, and fail to mention anything later which may be relied upon in a court of law, you could argue your defence otherwise. If you're doing a petition, you could remain silent, but you aren't going to get many signatures. If you tell people about it, then you likely are going to get some, or ask them. Now, you can't do that without the free speech, and, you are not really going to get very far if it's, to federal government or parliament without publishing it, So you're choosing not to remain silent, and it may harm the success of your petition if you don't publish it. when the number of signatures that you submit are relied upon in Parliament in order to decide whether it be debated or not. Or, you could choose to remain silent and get some people to sign a piece of paper. But if there's nothing written on it, what are you asking for? The more information you write and choose not to remain silent, the stronger your case is. And it will not only harm your case, it could actually assist and benefit your case the more information you give. In fact, if you give false or wrong information on the petition or in an election interview, or when you're on TV, being interviewed, in front of your candidate being interviewed in front of the people who are going to be voting for them, they have got the right to remain silent. But it could harm their election if they, come out with anything that is, incorrect or invalid. You've got the right to remain silent, but they've also got the right of free speech. And while those proceedings are going on, they're proceedings with the government, and you can't injunction it with a court. You can only challenge the results of the election or petition if it was not run legitimately. And as for the election or petition to be heard and adjudged is by the authority that it is addressed to when it's meant to be handed in. Now, you could say maybe Biden, because it's to the White House with Robert F. Kennedy, you could say that, it's open for judgment through the whole process, and then Biden's giving feedback saying, no, that's not true, that's not true, that's not true, whatever. But the thing is, the key thing about petitions is that unlike a court where you get the evidence and then you submit it to a court, and then they get everyone in and they get a jury in, and then they hear the case and have a trial, and then the jury decides, or if you've got 3 judges, and then the decision is made. With the petition to the public, you're actually trying the information to the jury, the whole jury, first, and then the opinion of the people, of whatever that opinion is, whether this is a load of tosh or not, is handed in, and then they decide. So they're not really supposed to intervene in that process, because if so, you haven't collected the opinion of every person. Now, if you want to say, no, well, they're lying or misleading them, well, there's loads of people lying or just get things wrong naturally. Things are done in error or mistake. It's impossible to be right all the time. No one's right all the time. It's just ludicrous. The whole thing that is wrong with this is the fact that it's not even going by what's legal or illegal. It's going by this policy that a company's conjured up to say that it is the arbitrator or can be the arbitrator in anything merely because you have agreed to its terms and conditions. But its terms and conditions must comply with the law of the state and federal and foreign laws. And state and federal and foreign laws say that they don't have the right to abridge or intervene in these processes, and there is actually a legal requirement to publish, and that is set out in the First Amendment, freedom of use of the press. What would you use it for? Well, what would you use the free speech for? Whatever you would use the free speech for. It's not the free speech of it doesn't say it is the freedom of the newspaper owner, his freedom to tell everyone what to do. It's what is the free speech? Is the freedom of speech in the First Amendment there so you own your own voice and you can tell other people what they can and can't say? No, it's the freedom for everyone to voice and debate. Therefore, the newspaper is included in that context of voicing things and debating them. That's why it's in the First Amendment and not completely and totally irrelevant and some random state law next to smoking indoors or outdoors. And this is why no state can make any of these laws either. None of them. That's the point in the federal law. The federal government can't make any law on this, or any states. That's the point. These platforms, YouTube, Facebook, they've got megalomania. They think they're governments, or the government is seriously misleading them. It's similar to what happened to the newspapers when they went over to that rigid free public notices framework at some point, and it was certain groups, a certain group and ownership of newspapers. So you could only do like birthdays, graduations, and so forth. They had a drop-down menu and made it very, very regimented, and it was meant to be a free system. That's what the law and rights are based on, and it's not the fact that they weren't, but they want what they. You could put petitions in there, but you likely would pay for them. They weren't actually refusing them. They were sort of kind of making you pay for it. Now, the thing with YouTube is this, and this is the thing that for me is just laughable for the whole thing. You can pay to advertise on YouTube. You can pay the money to advertise, but to look at it, to read it, is free. And it's not a private membership only club. In fact, it's so free that you don't even have to have an account to read the writing on there or look at it. So it's like a free newspaper. And all you need is an internet connection. Now, you can have a channel on there, but you don't even have to pay them to have a channel. They give you it for free. And you can upload a video for free. So, and your videos can advertise things like your political campaign, if you're a candidate, or petitions. So it is free ads. It is free ads. YouTube is free ads. That's what it is. Now, can they make these policies up or not? I don't think they can. They can't. Because it invites anyone on there to upload content. And the laws are that certain content has got certain rights over it. And that is in the First Amendment of freedom of the press. It is freedom of use of the press. And I actually believe that, I actually think that it is more, that there's more of, it's actually getting more and more and more evident that it might not actually even mean all of the press. Like, it might actually be, because of the 1688 bill, is talking about free speech in regards to political matters. I don't even think that the normal newspapers, The Sun, in their own stories and reporting, actually have got complete and total freedom like they think they have, to tap phones, listening, do all these wild, wacky stories and other things. I actually believe, why would it be in the First Amendment to do with federal law and petitioning the government and speaking freely? Because in order to do those things is in order to be able to engage in the government, it's the Bill of Rights and freedoms and liberties, all of those things listed there are itemised for things in relation to function and operation of the country and government, mainly to do with elections, speaking freely, political matters, military, standing armies, protecting yourself. It isn't actually really about the mundane things like, buying bacon sandwiches or whatever. It isn't about those things. So why would a First Amendment have petty or ridiculous, mundane day-to-day things, even, businesses, publishing books or whatever? That state law is, mundane day-to-day dealings in law. Federal law is about, because it is about getting the whole thing made and changed. So it has the mention of newspapers petitioning and free speech has to be in context of going about getting things made or changed or getting elected for positions, because this is all about the operations of government, which is what the Bill of Rights is about. Why would a first... I put this to Paul Groves and Neil Mohan, right? Why would the Constitution of America and First Amendment have anything to do in it with, someone, making a movie, making the Goonies, or, Bill and Ted's Excellent Adventure, or a book on fly fishing by J.R. Hartley? That's important. It's the Constitution of America. Oh, just a minute. Where is my book on interesting nose gobbling collections? Let's include that in the Constitution. Freedom of the press. No, actually, just a minute. The petitioning the government, getting laws made or changed, and speaking freely about that. And, oh yes, we need to be able to print it as well, or we're not going to be able to speak freely to many people about it. Yes, maybe it is to do with that. That makes sense now. It makes complete and total sense. Actually, the Constitution of the First Amendment of America isn't about, Mr. Beast and his channel. No, it's actually about publishing and using these mediums in relation to making and changing laws and the running of the country and engagement through politics. Because otherwise, we don't have any freedoms or liberties, because they'll subvert them all. Maybe we'll leave, Fly Fishing by J.R. Hartley to, the Billabong in South Carolina or whatever. This is it. I think, Rupert Murdoch, they're getting above themselves of their own importance. You see, they are their little business they started, that could go into the newspaper and publish an advert to sell some chips or whatever. Now they've got these mighty empires and they're suing these governments. They think the American Constitution is written all about them, all about private business. When does the First Amendment mention a private business? Once in here. Can you see anything about private businesses in this first section of the First Amendment? No, none, nothing. Does it mention private businesses? Once. Does it mention private businesses in the Bill of Rights? No. Well, why the frick does Mark Zuckerberg? Who the frick does Mark Zuckerberg think he is? Abraham Lincoln. It's like Abraham Lincoln or Mark Zuckerberg. I am Abraham Lincoln. No, you're not, Mark. You're just a guy with a platform. Getting filed. This is it. These people think that these laws, because they're doing all this suing governments and lobbying governments to get laws made and changed, they actually think the main Constitution of America is about them, their business and their rights of owning a business. Actually, since when does it mention anything to do with commercial enterprise at all? Whatsoever. None. Nothing. Zero. Zip. Nothing. In fact, it does not involve private company or businesses whatsoever. It's actually the principle of the freedom of that medium for everyone. The freedom of use to it, which, if you don't want to have a platform where everyone comes on, then don't have one. Because YouTube is not a private platform. They've provided a public, accessible service, readable, watchable by all the public. It's not private, it's privately owned, it's not a private business, it's not a private platform. It is not a private platform. It's never been a private platform. And if they made it a private platform, then they wouldn't have made so much money. They've only made money because they've let everyone on and let all subjects and content on. That's what's made them their money. And now they want to be able to pick and choose, which, if they'd have done that at the start, they wouldn't have made all that money. This is the thing. So they believe that the constitution of the country is all about them and their private businesses, when actually it's got nothing to do with private businesses at all. It's about the freedom and rights of use of mediums so we can engage in and participate in politics without hindrance or abridgment through the mediums of speaking and publishing and being able to bring a case, having the right to petition. It doesn't actually invent it. The right is that the other party doesn't have the right of intervention. It's all actually about the other party. It's not actually about the petitioner, really. It's about other parties. It's about other parties who are not allowed to do certain things. It's not actually about the person who's petitioning. It's all about the people who aren't the people who are petitioning, the judges, the ministers, and so forth, who can't bring prosecutions or intervene. The right to petition, it is all about who doesn't have the right to intervene in it. And that's why you've got this 5013C, illegal campaign intervention, which they seem to be completely, and a petition is not for profit. A petition itself isn't for profit. So, it's non-profit. So, how is it not a tax-exempt entity when you're not selling anything, And as for, illegal campaign intervention by tax-exempt organisations, every person who engages with it is a tax-exempt entity for their actions in doing that petition, whether they're publishing something, writing it. It's not done for money, for a profit. It's done for a decision from government or a practice. So every single person is a non-profit entity, and they're not allowed to intervene in each other. That's the thing. So when we all engage in politics, when another person is, engaging in politics, we're not allowed to intervene illegally. But when we're also acting in a political capacity, and the other person's acting in a political capacity as a citizen, they're both a tax-exempt, non-profit entity in that action and engagement. So they can't intervene. They're not allowed to intervene with each other. And this is what YouTube's policies got on. They're not allowed to use the platform to obstruct and so forth. You're allowed to oppose, which means say, I don't support this or I don't support that. Or you can choose not to vote at all. But you're not supposed to sabotage other people's procedure. And these big platforms, this is the thing. If you really aren't keen on people publishing political material, it's best just not to have a newspaper or a video platform, because it's the wrong thing, Or really make it private by having it like members only, which on Facebook they've started to make it so you join these Facebook groups, like specific groups that you join. But the thing is, what happens when you get into debate in a private group about a matter, and then it gets an argument over the law over that matter, and then you need to, challenge or check it up. They went through all these issues with, speaking freely in private. And free speech, it applies in private and public, because you won't be able to speak your mind in a pub otherwise, and a pub is privately owned. But the thing is, YouTube almost is like a pub in a way, but without alcohol. It's privately owned, but you walk into it and you're meant to be able to say what you want, as long as it doesn't actually break the law. But then they've got all these ridiculous policies. They just didn't have these policies, and it's an overreach. No one's calling them out on it. Why? Because who's got the money to, who can afford to call them out on it? And then they kind of like people calling out on it. In America, they love suing each other, particularly like for copyright and things like that. They think they can sue each other over anything. But the thing with the petition, when you are proving a case to the government and you're getting the public to look at it, you're showing them evidence. Oh, look, we should do this. We should change the law in that. Well, what can you show me to demonstrate that? Let's have a look around. Oh, actually, there's a picture in the New York Times. I'll show you that. Look, this is evidence. This is why. Don't vote for Donald Trump. He's got a funny hairstyle. Has he? Well, show me. Well, there you go. In the newspaper, there it is. It's evidence. For whatever it is you're trying to demonstrate, you're proving something to people, and you've got to think of, what can I use to demonstrate this fact to them? Why should you vote for me? Because I'm intelligent or proud or whatever, or, like Marianne Williamson, she's a long-established writer, or, Robert F. Kennedy, he's a professor, or he's an environmental lawyer. I am an environmental lawyer. Here is the evidence. I am telling you through free speech. Here is a magazine. It's evidence with the article, Now, if they don't believe it, this is the thing. This is why in court proceedings you have to get the jury to, believe you. It's up to them to decide. This is a thing that Biden doesn't understand or get. It is proceedings inside out. It is proceedings to federal government, and it is predates actually even civil and criminal cases, and it is performed inside out, a different way around. There's not really much anymore to say unless I get get my research scholar to confirm everything I've said. Some of what I've said can be confirmed through research, like Karen Barry's paper. But then again, you've got to get, how do you even prove what I've said? Through evidence, facts, information to support it. And then on logic, is that logical? Does that make sense? This is it. Examining the Bill of Rights. This is why we've got Professor Karen Barry's paper. This is the whole point in it. But when you're up against YouTube, in civil cases, both parties have to be on the same foot, on the same grounding. No one's on the same grounding with these big companies. And now, the legal costs no one can afford them, and then, the lawyers are misleading people, or they just don't understand it themselves, and no one really understands court proceedings properly to go themselves. This is it. So it is, the freedom of the press is there together with, it is the extension. It's like the third extension. You've got the right to petition and free speech because it's required for it to function, perform the function. And then you bring in the press, because without the press, you can't really, you haven't got much capacity or scope without the press. So it has to be the freedom of use of the press as well as the freedom of use of the free speech. Now, as for ownership, well, this is the thing, why would you open a megaphone company if you didn't want people to, it's a privately owned company, but anyone can say what they want through a megaphone. When they sell a megaphone, they don't say, you have to consent that you won't talk about politics through it. This is, now it's yours. Well, this is my account on YouTube. This is my channel. I can talk about what I want on my channel. It's not your channel, it's my channel. But we own the platform, well, the government own, His Majesty owns the kingdom, a horse, my kingdom for a horse. Oh, it's a public notice board by the council. Oh, it's the king's. Oh, here we go again. No, you cannot use the king's notice board to put your petitions in. Oh, it's that old game, is it? I cannot use the king's notice boards to publish my petition in the village. You, remove that petition from the village notice board. No, there's a new king in town now, King Cocomelon. It's Neil Mohan and his sidekick, Paul Groves, the new kids on the block. hey, you can't publish those petitions on our YouTube channel. Oh, that old chestnut, is it? Well, we had a guy coming round here before, called himself the king. He said we couldn't do anything. But then we got the liberties of the realm were being subverted, and with these evil judges. And now we've got evil lawyers like, Black Belt Barrister, possibly, or even Alan Robertshaw. Woo! This is it. Same old story. And I don't know, this is it.